And we are back again with our wonderful friend Arthur Crooks, Attorney Arthur Crooks. And this is a second part in a two-part series. And we're going to be talking today about special needs trusts. Not a simple topic, and all kinds of different people that you might not even think of fit into special needs trusts. So it's a very important topic, and I'm going to let Arthur take it away.
Thank you, Barbara. And what I'm going to be doing when we talk about special needs trusts is linking them into some of the other talks we've had, including the basic estate planning documents you should have in place. For instance, in a power of attorney, you can have a provision that I authorize my attorney-in-fact, that's your agent, to fund trust, to fund a special need trust if that is something that's appropriate in any given situation. If we go back 3 or 4 sessions to wills and mass health planning, I mentioned wills with testamentary trusts between spouses and how those are so helpful. Basically, the type of testamentary trust that's helpful in those situations is a special needs trust, because they're designed for someone who may be in a nursing home. And I think by definition, if you're permanently in a nursing home, you're someone who could be classified as special needs. So, and then there's the whole concept of trusts themselves, which we spent a session on. So I'm going to try and link those all together. Basically, these are trusts for people with special needs, disabilities, and we're going to get into how those are defined. This is a very complex area because a lot of it's governed by federal law. And it can be a win-win situation. And the way it can be a win-win situation is, let's say you have a child, or it could even be a grandchild, someone who you want to benefit in some way. And if that person has special needs and is receiving some type of government benefit, be it what we call SSI or SSDI, they have rules which govern their eligibility. And sometimes an unforeseen inheritance can cause havoc with their the compensation which they're receiving from the government. So there are ways that we want to be able to remember that child or children, grandchild, without upsetting their benefits. Now, that's a win situation for that potential beneficiary. The other win situation is, going back to when we talked about mass health and the fact that you can't give money away, there is an exception. Money which you designate or place in these special needs trusts are exempt from a lot of those rules. They're not considered disqualifying transfers. So in any given situation, if you have money and you want to remember or give it to a child or a grandchild with disabilities, if you do it correctly, you're going to benefit them and you're going to benefit yourself potentially. One of the things I'm seeing more and more of, and I think there's an emphasis in estate planning, is on intergenerational planning. I was at a gathering last November, a national gathering, and they really emphasized this, that after 9/11 and with all the economic problems we're having, there's more of a turning in, especially in families, that they want to protect what the family has. And if you have a disabled child or grandchild, that offers opportunities, as I just talked about. So, for instance, if someone comes into my office and I'm just doing a quick rundown, and I'll ask, well, how many children do you have? And they'll list them, and grandchildren, and then I'll say, do any of your children or grandchildren have any type of disability? And if I get a positive response, I just put a little check mark there to come back to that. I have a situation now where a client came in, and he has a son and a grandson. And he wants to do some planning to assist the grandson. And as I looked at what he wanted to do, I said, you know, and I know his son also, I said, we should be approaching this from the other end. not what you're going to be doing presently. He's 86. We should be looking at your grandson, who's 15 or 16, who has a profound disability, and we'll do the planning from that direction. So I contacted the person in the middle, who is my client's son and the father of this child, and he's told me over and over again he's going to get into the office and do some planning. Because here's a situation where we have to do generational planning. We have my client, the grandfather, then we have the son, and we have the grandson. If we can do this, put all this planning together, it's going to multiply the benefit that everyone involved is going to receive. So this is what I see more and more of, and I just did one yesterday, a very complicated situation where it's a grandchild with special needs, and we want to make sure that if his parent predeceases my client, who's the grandfather, that money just doesn't flow to him directly, because number one, he may lose his benefits, and number two, what is he going to do with it? Who's going to be in charge of it? So there's all different ways that this can be accomplished. So, and I call these safe harbors, and we're going to discuss them in the context primarily of the federal rules and regulations that govern this. I was at a meeting about 2 years ago, and they were talking about sort of the perfect storm that we have going on now. The baby boomers, the first of them turned 65 this past January. They're coming along, and they're going to want all their benefits. They're going to want Social Security. We have a government that is profoundly in need of money. And then we have younger people, young kids. I've heard a statistic that the incidence of autism among young boys may be as high as 1 in 50.
Wow.
So we have a whole new,
huge.
It is. It used to be 1 in 150. Now it's on the autism spectrum. We have everybody expecting and looking for benefits. And where's the money? So what we're trying to do is tie all these things together. So I already mentioned the fact that the testamentary trust, which we've already talked about, doing in your will if you're interested in nursing home planning, this is a form of what we call special needs or supplemental needs trust. And that's for the benefit of your spouse. Now, I'm going to review some of the terms that I've used before. We're talking about trusts. So let's go back to what a trust is and how trusts are created and how they work. A trust is just something wherein assets or money is being held in a form where you have the settlor, the creator, or the donor. Those terms are interchangeable. And let's just talk about here about a parent with a disabled child. The parent is the one that's going to create the trust usually. And so they can be called the settlor, the creator, or the donor, interchangeable terms. Creator is the one we kind of favor because of its implications it has in the federal law that governs a lot of this. Then you have the trustee. The trustee can be the parent, it can be another child. Sometimes it's an organization, and we're going to talk about a special type of special needs trust called a pool trust a little later on. And then there's the beneficiary, who is generally the person with the special needs. These trusts can be revocable or irrevocable, but they are generally, almost without exception, irrevocable. And that's done so that we are going to maintain this benefit for the whole life of the beneficiary, and to gain those favored treatments by the government when we're talking about both benefits for the disabled person and if you were looking for Mass Health / Medicaid benefits. These trusts can be standalone trusts. They can be created outside of any other document, or they can be included in other documents. You can have a special needs trust within a living trust that you do for tax reasons, or as I pointed out before, they can be inside a will. Sometimes people will say, well, I don't want to do that because that means I have to probate the will. But when the new rules come into effect for probating wills January 1st, 2012, that's not going to be the impediment that it used to be, and I think you may be seeing more of these. So again, the key here is we're supplementing benefits that someone else is receiving, your child or your grandchild. We're not supplanting them. So when we talk about these, we're talking in the context of a public benefit your child or grandchild may be receiving. The key to this is, and the two benefits we talk about most commonly are SSI,
Right.
Social Security Insurance, or SSDI, which is Social Security Disability Insurance. The key concept in Social Security rules and defining someone who's disabled all revolves one way or another around the ability to work. If someone can work, then you're probably not going to be fitting into one of these categories. If someone has never worked, they're more than likely going to be on SSI, which is Social Security Insurance. That's akin to an entitlement, a welfare type benefit. This is the person that has no work history. Conversely, the rules that govern here are much stricter than the rules that would govern if the benefit you received was SSDI. SSDI is akin to your regular Social Security. That's an earned benefit that you have earned by working a requisite number of quarters. I had someone in the office the other day who had worked for many years and then received an injury which precluded her from working, and working of any nature, and she has since been on SSDI. It's possible, and don't ask me for an example, that you can be on both.
But don't you think that's one of the things with the special needs trust people are a little hesitant about is, I don't want my person to lose those benefits, and they think that because of the trust that they will.
No, that's why they're special needs trusts. These are special trusts that are designed so that you don't lose the benefit.
Right.
That's the key here. And I'm going to be talking about those, and that's what we're attempting to do here. Let me give you an example. You have a special needs child is on SSI, for instance, and a wealthy uncle dies, and in it he's left a little amount of money to everyone. And let's say the special needs child is Johnny, and he says to my favorite grandson or nephew, whatever, Johnny, I leave $50,000. We have a problem now, because Johnny's going to get $50,000, and if he's on SSI, the limit there is $2,000. Whoops, what do? Well, I'm going to talk about what we do. One of the things that we will be doing when we talk about this is there's a certain type of trust which you could establish right now, and it would be called the Johnny Jones Special Needs Trust. So the next time there's a family gathering, be it Thanksgiving or 4th of July, you'll just wrap your fork on the glass and say, I want to make an announcement to all my wealthy uncles and relatives here. If you want to remember Johnny in your will, leave the money in the will to the Johnny Jones Special Needs Trust. That bypasses all of these other considerations and goes into a trust which we hope is going to be exempt from excluding Johnny from his benefits. And that's what this is all about. That's what we're going to be talking about. And you got to be careful here. So what I'm going to do is I've got a little chart here I'm going to be referring to, and I'm going to try and break these down into two general categories and then with a subcategory of one of them. Johnny's going to come into some money. The first thing we have to do is analyze what is the benefit that Johnny receives. Is he receiving, and we're only doing this because he's receiving a government benefit. He may not be receiving any benefit at all, but there may still be a reason why you want to set up a trust like this. But if he is receiving a benefit first we have to analyze what is the benefit he's receiving. SSI or SSDI, they have different rules, okay? And we're going to come back to that in a little while. Now, where is the money coming from? That's the second key thing we have to analyze. Is it Johnny's money? Well, how would it be Johnny's money? Quite frequently, Johnny may have wound up disabled because he was in a terrible automobile accident, for instance. The lawsuit was settled, and Johnny's going to get $2 million. Well, obviously, if Johnny's very young and he's on SSI and probably will be the rest of his life, that $2 million is going to exclude him from any benefit. And that money could be used to buy him a nice house, a nice car, with all sorts of disabled amenities. So we don't want that removing him from his benefit. The other thing, as I mentioned, it could be an inheritance. Maybe that uncle left him a real lot of money, and we don't want that happening. So we analyze then, where's the money coming from? If it's Johnny's money, we call that in legal terms, the type of trust we want to do is self-settled. In other words, this is a trust that we're going to use to deal with his money. Now, the other kind of thing, let's move to the other side of the bracket here, is if it's someone else's money. In other words, that the rich uncle may want to leave money, and if he does it properly, it never becomes Johnny's money. That's the one where he would do it through the will. Or the most common is it's your money as the parent. And you want to make sure that Johnny or Susie, as a disabled person, is taken care of. And you want to do it in such a way that you don't disqualify them. And furthermore, if you do it properly, you will not be disqualified if and when you have to go into the nursing home, because that's the double win. If you do it properly, it's not going to be considered a disqualifying transfer. When you look at the Mass Health rules, they'll say transfers for the benefit of a disabled child are not disqualifying transfers, as long as you comply with a whole host of technical regulations. Now, I'm kind of looking at my board here, and I guess that will be brought up. So as I define these, I'm going to go on the left-hand side. You'll see first. That means the self-settled trust. That's the money that actually belongs to Johnny. On the right-hand side, you'll see a third-party trust. That's the money that's coming from the parent or the uncle or anyone that just wants to give money for Johnny's benefit. Now, again to the chart, on the first side, the trust that's generally done there is something we call a D4A, and that is just there's a long federal statute that defines what a D4A trust is. It's preceded by a lot of numbers, and the D4A are just the final numbers. So these things are known informally as D4A trusts. And primarily here, we're probably talking in terms of someone who's on that SSI benefit. Remember, the rules are much stricter there. So let's look at the requirements to do one of these so-called D4A trusts. Remember, this is the trust, it's Johnny's money. So think a personal injury settlement. I've done a few of those recently. Or think, oh boy, we have a will that left Johnny $100,000 outright. We got to do something about it. So we got to get it into the D4A trust. So what are the requirements? Number one, Johnny's got to be under 65. That's usually not a problem. And as we've already told you, it has to be his money. That's the beneficiary's money. It has to be irrevocable. That trust has to be irrevocable. And as I said earlier, most of these trusts generally are irrevocable. It has to be for the sole benefit of Johnny. In other words, it can't benefit anyone else. The example I use is, let's say Johnny is living in a group home, and you use the trust to buy a television set for Johnny. If you put the television set in the living room, that's not a sole benefit for Johnny. The television set has to be in Johnny's room only. And we can get angels on the head of a pin defining what's sole benefit and what is not. Now, back to the chart again. One of the key aspects of the D4A Trust, remember, this is for Johnny's money. There has to be a payback clause in that trust to pay back Medicaid for any Medicaid benefits that Johnny has received during his life. That's mandatory that that be in the trust. Now, the goal with any of these trusts is that there be nothing left over. That if you have, let's say, 100,000, 200,000, a million in a D4A trust for Johnny, and he's 20, and he's going to live a full, long life, the idea is you want all that money spent. However, let's say Johnny passes away during the course of this. Your trust can provide for beneficiaries, but the first in line is going to be the payback to the government for the Medicaid benefits. Now, another oddity about this trust is the creator. Remember I talked about these trusts, for some reason, I don't know why, they can only be created. Remember, it's Johnny's money, but Johnny can't create the trust. It has to be created by either his parent or grandparent or his guardian or the court. Now, lots of times, let's say Johnny is 50. He may not have a parent or a grandparent still alive. Okay, so we have to scratch that off. He may not be under a guardianship. Then that leaves us going to court. But let's get back to the guardianship. The program we just presented prior to this one was about guardianship and conservatorship law in Massachusetts. And we talked about the fact that under the new law, the only person that's handling your money is a conservator. Your guardian no longer handles your money, has nothing to do with your money. But the federal law says it has to be a guardian. Conundrum. We're stumped. We don't know what to do.
You had the conservatorship to begin with, but you didn't have a guardian because all you wanted was the money piece. You now have to get a guardian for this trust?
No, guardians can't do financial things. It's a catch-22 of the first order. Always has been a problem, but we could usually get around it before by just going in and getting authority of the guardian. In the program where we talked about guardians and conservators, it was not an advanced seminar. There are some things people are trying to do, but this has always been a problem, and now it's magnified because the feds are very, very sticky about that. They want it to be a guardian. They have these rules that are called POMs, and they're similar to the IRS regulations. There's something I don't spend a lot of time delving into, but they're very, very insistent upon that. So that's a work in progress as to how we do that. But let's say we don't have a guardian, we don't have a conservator. All we have then is we have to go to court, and we have to go to court in the probate court on what we call an equity petition. When we go to court, and this gets back to Law 101, there's legal matters and then there's equity matters. Equity is sort of throwing yourself on the mercy of the court and begging them to do something that's fair and just, even though there may not be specific law. So you have to present a long equity petition. And I was reading some of my materials this morning, and it said, practice varies from court to court. And it sure does, because you don't see that many of them. And generally, if you do them right, the court will allow you to create the trust as petitioner. The court doesn't want to do it. So that's very, very complicated. And these trusts themselves can run anywhere from 5 to 6 pages to 50 pages. They can go into all sorts of detail about what you want the trust to accomplish. And you better make sure you've dotted every single I and crossed every single T, because these trusts will be examined by the Social Security Authority, and they'll say, you know what? This was created properly, it was funded properly, and we're not going to touch Johnny's benefit. This was done the right way. This is a D4A that was done the right way. Johnny's $700 or $800 a month is not going to be touched. Okay. The next step is, how is this trust administered? You can have the trust set up perfectly, wonderfully clean, and the Social Security likes it. But the next level we get into is what you do with that money in the trust. That can cause problems. But before we get there, let's shift over to the other side here to what we call the third-party trusts. These are a lot more flexible because you're not under all these federal regulations. These are just classic, old, plain vanilla trusts. Therefore, they can be revocable. Generally, they're not, but they can be. And it's other parties' money. The ones that are revocable are generally going to become irrevocable when the creator or the grantor dies, which is usually the parent. Okay, now here's where a lot of people get in trouble. Going back to the chart, there is no requirement for a payback clause under the third-party trust. If you do have you've created a rather large third-party trust, and you've done this for one of two reasons, or maybe for two reasons. You may be on the eve of going into the nursing home, and you may be a single person, and you'll recall from past presentations that there's not a lot a single person can do. But if you have a disabled child and you have a proper trust, you could transfer that $300,000 you have into that trust, and there's no payback for you. But there is a payback for the Medicaid provided to the beneficiary. Okay, you got to keep that in mind. And what happens is some lawyers that are dabbling in these trusts can sometimes put a payback here for the person that's actually donating the money, and that's a no-no. We don't want to do that, because then you've destroyed half the purpose of why you've created the trust. Again, kind of complicated stuff. Be careful where you tread. You may have an unintended impact if you do something wrong. Now, kind of in the middle, floating around here, is something called a pooled trust. What pooled trusts are, these are very, very generally small trusts, $10,000, $15,000, $20,000, $25,000, that you want to create for a child, but you don't want to pay all the legal fees attendant. Pooled trusts are just as that implies. They're run by charities generally, and you lump all of the trusts in together, and they may charge you $500 to create it. They become the trustees of this trust, and it's for small amounts of money. So you accomplish the same thing, but in an easier way without all the attendant costs. And there's a couple of charities in Boston that have these pooled trusts. Now, I could spend a whole lot of time talking about pooled trusts, but I'm not going to do that. But here's one major, major benefit of a pooled trust. You may recall that when we talked about doing mass health planning or Medicaid planning, that if you're a single person, there's not much you can do. However, the pooled trust does not have that under 65 requirement. You can have a pooled trust and be over 65. So, let's say you're on the eve of going into a nursing home. You have that $300,000. Let's make it $100,000. Make it a smaller number. And you have no disabled child to leave it to. Your power of attorney, whoever's helping you getting into the nursing home, is going to be wondering about that $100,000, and they may look into a pooled trust. A directive came down about 2 years ago from Social Security that they did not think it was appropriate that people over 65 could use these pooled trusts in this method. But they haven't done anything yet. The mass regulations still allow it. So here's what happens. You take that $100,000, you put it into the pooled trust. That's a permissible transfer. It's not disqualifying. So Auntie Mary, the next day, is automatically down to her $2,000 limit and goes on Mass Health that afternoon, if it's done properly. Here's the catch. The pooled trust does have a payback requirement. So if someone is considering doing this and Auntie Mary only has like $20,000 and she's healthy, you're going to be paying back out of that trust each month that she's in the nursing home. So if the nursing home, what you have to pay back is going to be $6,000 a month. If Auntie lives 3 months, well, she's going to wipe out the trust anyway. So does it make a lot of sense doing it? As you get into higher amounts, it's almost like gambling on how long you think she's going to live. So I don't know. It's there, and again, it's a disability trust. And generally, if you're in the nursing home permanently, it's a given that you qualify as a special needs person. Okay, so those are special needs trusts in a little tiny nutshell. Whole volumes are written on this. Whole law firms in Boston do nothing but this. So we're just touching on and as you said initially, well, people are reluctant to do a trust. They should be, unless they're doing one of these types and they're complying with all these rules and regulations. If they do, and you can have both. You can have a D4A for your own money, and then you can have a third party, and some people do that. They want to be covered both ways. Okay, so that's basically how you create these trusts. And they can be very complicated. They can have all sorts of clauses in them about how you treat Johnny, where the money's going to go, if there's any left over, et cetera, et cetera. But let's come back to the benefit again. Is it SSI, which is the entitlement, or SSDI? If it's SSI, you got to be very, very careful how you spend that money out of the trust. In SSI, you have an income limit of $20. I don't want to get into the income limit, but the asset limit is $2,000 countable. That's why you want to get it in there. Qualification, again, these are all defined in the Social Security regulations. Most of them, when you get down to it, has to do with whether you can work or not. There's, if you're blind, if you're elderly, basically if you're medically disabled, you're going to qualify for the SSI benefit. And that's a whole other application process. That's a whole other world, Social Security. So, and if you do qualify for this particular type of benefit, you're going to get Medicaid automatically. Now, here's where it gets tricky. We have a D4A trust. What can we pay for out of that trust? And before I get into what trusts can pay for, I want to hit the high points. Up until a few years ago, these trusts could not pay for anything having to do with a rental where you live, okay? The rental, you can't pay. The utilities, you can't pay, etc. We can't pay for food. And up until a few years ago, you couldn't pay for clothing. Now, the clothing has been knocked out. So these trusts now cannot pay for anything having to do with your rent or anything having to do with your food. Why? That's what your benefit is for. If you're getting your $700 or $800 a month as a benefit, that's supposed to pay for your food and your shelter. Let's say this trust has $5 million in it, and you really don't care about losing your benefit. If the trust goes ahead and pays rental, etc., you will get your benefit reduced by no more than a third. So you might say, what's the difference? I don't care. But if the trust only has $50,000 or $60,000 in it and it's supposed to last your lifetime, it's a balancing act as to whether you're going to pay out. If there's a ton of money in there, maybe you don't care about your benefits so much. Now, one thing you cannot do, and this is what we do, we're guardians and trustees of a lot of these trusts. No cash to the beneficiary. And the people who are out there who are beneficiaries, let's say they're on SSI and they all go to the clubhouse in Hyannis or wherever, they're constantly, shall I say, scheming as to how they're going to get money out of these trusts. My favorite was someone who was from this area. He loved books, so we would send a check to him or to his aide, to Borders, for $100. He'd buy 3 or 4 books. He was doing this every day. You're thinking, this is a very well-read young man. What he was doing with those books, he'd buy them at 11 and he'd cash them in for cash at 2. Okay? Wow. I have another person who sends us a Shell credit card bill every month. It's generally $400 or $500. And I know she doesn't drive that much. She maybe drives 50 miles a month. Why? You can go to the Shell station on 134. What's in the middle there? A little store, right? So you can go in, buy your groceries at 3 times what you'd pay in the supermarket, of course.
And your cigarettes. And
your cigarettes and everything, and submit the bill to me. Now, I kind of know what's going on. But am I going to make a federal case out of it? Probably not. So this particular person is buying all of her food there, so when she gets the benefit, she can party with it or whatever. And every once in a while, she'll tell me, I can't pay my rent. I'll go, they're going to catch up with you someday. And so we'll pay the rent, with the idea being, well, she's going to be on the street if we don't, and the most it's going to cut into the benefit is 1/3. When you do these D4As, you're supposed to send them to Social Security so they can look at them and make sure that that Johnny is going to still get his benefit. Quite frequently, you never hear back from him again. So, we've already talked about how to establish these trusts and what the rules are. So, I indicated to you earlier that you can't use these D4As to pay rent. But let's say that is and I have had a case like this. Let's say it is a personal injury settlement. It's that $2 or $3 million. You don't have to pay rent. The trust will buy a house. The trust can own the house. And this has happened. I sometimes call this the Beverly Hillbilly syndrome. Because if you get a nice enough house, the whole family moves in with you. And then that's when the problems start, okay? So you can buy the house, and then we don't have to worry about rent or anything because we're not doing that. The trust will be paying, and that does not become an issue. Now, anything else, if is cable vision part of your rent? I don't think so. We can buy certain things for you. We can get a car. I've got someone now that we've just created a special needs trust for. And the first thing I'm going to do is get a car. The person can drive. She's on SSI, but she has a license. So you're entitled to a car. One of the things that's happened, though, is the way we're funding this trust is we just sold the house she was living in. And she has no concept that, this does not qualify you for public housing immediately as an emergency because you sold the house you were living in. But we come to find out there's a 2-year waiting list to get into public housing. So we have to make that decision now. Are we going to pay over and above what her benefit provides to put her into housing with the idea that we're going to lose 1/3 of the benefit? And we probably are, because what else can we do? So a lot of these, a lot of these things are balancing acts. But as long as you're paying for something that's not housing related, transportation, et cetera, trips, vacations, one of the problems you have is the sole benefit concept. We're going to send Johnny to Disneyland because we know he'll love it, but we have to send someone with him. So is this for the sole benefit of Johnny? Because that other person's probably going to enjoy themselves too. Again, we're getting into angels on the head of a pin. You know, how is that going to work out? So anything we're going to provide out of these trusts, and again, we're talking primarily about this D4A type trust with a person on SSI. We're going to pay directly. If it's, I just talked to a young man yesterday who I discovered as I talked to him that the trust he had was a special needs trust. I didn't know that till I looked it up. And he didn't know it either. I said, well, let's back up a giant step now. I can't pay for your rent, and I can't give you direct money. You're taking driving lessons, I can pay for those. And then when you want to get a car, we can pay for that. Total amount of money in this trust, $10,000. So I've got to be careful because the primary reason we have it is, I think, to get him a car. But if I start paying all these little things, there's going to be nothing left for a car. So we have to be careful there. Now, let's move back over to the third-party trust, and let's say it's someone at SSDI. Well, then it's sort of who cares, because the rules are not, you still have to be medically disabled, but they don't have all these rules and regulations on how many assets, et cetera, et cetera. So there's basically no limit here. Now, where you will see this trust quite frequently is what in the nature of a spendthrift trust. Let's say we have someone who is medically disabled and they're of a certain age, maybe they're in their mid-50s, long work history, but something has happened to them and they can no longer work. The particular case I'm thinking about, this person has kind of become a street person, and he is a spendthrift. If you give him $10, it'll be gone in 5 minutes. Give him $100, it'll be gone in 15 minutes. Give him $1,000, that might take him an hour. Well, right now, his mother is quite wealthy, and she's going to be leaving, when she passes away, a significant amount of money. So what we've done is, yes, you can leave the money to Peter, yes, you can leave the money to Susan, but you are not going to leave the money to Jimmy outright, because it may not take him off benefit. But if Jimmy gets $1 million in his hand, he's already promised a couple of women he's going to marry them. When the word gets out on the street how much money Jimmy's coming into, I'm sure he's going to have no problem finding someone, and he gives the money away. So we've created a trust, not so much to dole out benefits to him, is to keep the money out of his hands so that he doesn't squander $1 million in, say, a month. And that's called a spendthrift trust in the context of a disability trust. So, we could spend a lot of time talking about the management of these trusts. They have tax returns. There's tons of paperwork. In a way, they're similar to guardianships. But what I wanted to give you is just a quick overview. Again, there's whole volumes written on this. There's several attorneys in Massachusetts who are national authorities, and I will call them occasionally with a problem, and they'll say, that's a good one. We've either never heard of that one, or the one or two times that's happened, we'll do the following. So a very, very complex, complicated area. And I just wanted to give you a quick overview. The things I want you to take away from this are, if you have a disabled child or grandchild that's on a government benefit, there are ways you can benefit that child or grandchild. I have a publication here from the Special Needs Answers, it's Special Needs Academy. 9 costly mistakes that you can make in this area. Disinheriting the child, that seems to be a solution. We just won't leave him anything. That way he won't lose his benefits. Well, that's true. My favorite is, we'll leave it to the other kids and they'll take care of them. That in a dime will get you a cup of Starbucks coffee, okay? Totally ignoring the special needs when creating the trust. You have to do that. My favorite, personal, procrastinating. One we've already touched on, failing to invite contributions from others. Thanksgiving, Christmas, what's next? Easter. Memorial Day, Easter, I forgot about Easter. Make a little announcement. We've got that trust in place for Johnny, and when you make your will out, I'm going to give you the name of that trust and the date it was created on, okay? That way, we do a complete end-around run on having to do a D4A. Some attorneys will say doing a D4A is a failure to do something over here, where it's much easier, much less restricted. Of course, a lot of the D4As are created by the auto accidents. I don't have that many of them. Most of the D4As I wind up creating are for the inheritances. Johnny was left $100,000. Johnny was left $50,000. We got to do something about it. And when I don't have a parent, grandparent, or guardian, I'm off to court. And it gets very, very complicated. So this is what you're going to announce at Easter, that you've created a standalone trust. It's just called the Johnny Jones Supplemental Needs Trust, date of creation, March 31st, 2011. And that's exactly what Uncle Henry will put in his will. That's who he's going to leave it to. Okay, very, very important. Choosing the wrong trustee. We could spend 10 hours talking about that. Most people are going to pick another adult child. Is this child going to be able to put up with Johnny calling 35 times a day, asking for the same thing over and over, asking for money? You need the ability to say no. So sometimes you have a co-trustee. The co-trustee can be a professional. If you've got several million, you may get a professional, you know, the law firm or a bank may be willing to be trustee. But you have to have the ability to say no. Relying on your other children to use their money. I think we've already talked about that. Protecting the special needs child from predators. This could be the case I just talked about, the street person. When the word gets out on the street that he's got $1 million, they'll be flocking in like the seagulls, okay? Then the failure to properly fund and maintain the plan. So if you do all of this correctly, you're going to make sure that Johnny is cared for. There's no reason why Johnny shouldn't have an inheritance. It just has to be done properly. And then the second part, if you do it properly and you have to go into a nursing home, these are not disqualifying transfers. Win-win on both sides. Special needs trusts in a nutshell.
Now, one of the questions that comes to mind we get a lot of, I'll just use my family as an example. My father-in-law is 83, soon to be 84, and pretty good health, and he is looking to leave X sum of money to my sons, now 20 and 16, for, say, college, and their futures with hopefully someday spouses. And they're not disabled, but they're right now 20 and 16. He has talked about the unified gift for minors, where you can leave X amount of dollars.
Right.
What would be an advantage, or would it be an advantage to doing something like this versus the UGMA?
I don't know a whole lot about the UGMAs because I generally tell people to go to, you know, wherever you're going to create them. But when we talked about trusts earlier, I quoted Professor Maitland saying that the trust is the greatest invention of the English common law. You can set up, and I'm just talking in terms of a trust that would be set up. The relative you're talking about can set up a trust with a trustee that is directed to do you know, certain things or within their discretion, or you can go into detail. Some of these special needs trusts actually have a little biography of the person built right in. And then the person that creates them has a letter of intent. It's like a letter to the trustee saying, this is outside the trust. These are my wishes for my son during his life. I want this done for him and I want that done for him. He likes to have this particular candy bar every Friday, something like that. You can sort of do the same thing with a trust. You can have letters of intent to the trustees. You have to have a certain amount of flexibility in a trust because the trustee has to have some discretion. But in those situations, I'm trying to think of the way I do them. What we do in those trusts, we say if they're going to go to a minor, and it's sort of an under 25 situation, okay. And we say that the trustee, within their discretion, shall use this money for maintenance, care, support, or education. And when I do them, it's always with an eye towards education. I figure if you're 21 years old, just getting out of college, putting $1 million in your hands is probably not the greatest idea in the world. Mm. Now, you can create whole trusts that just have to do with funding of a special nature, outside of a special needs trust. Lots of times these things are done, the special needs just happens to exist. You can do these as standalone spendthrift trusts, educational trusts. Each one is fact-specific as to what is the best way to accomplish it. Because when we're talking about other things, and we're talking about an 84-year-old, I'm starting to inch over to, well, what are the mass health implications here, the Medicaid implications? If it's done by a will, then we don't have to worry about that because the person has passed away in any event.
But if he should have to go to a nursing facility, that's
what we
hear all the time.
When I describe basic estate planning, as we've done here, Roman numeral 1, what do you have, and who's going to get it? Roman numeral 2, if you have a lot of stuff, it may be subject to estate taxes. And Roman numeral 3, what happens to all of these wonderful plans if I have to go in the nursing home at $11,000 a month? Then all bets are off. So it's a balancing act. You don't want to do something here like, oh, I'm going to give $50,000 to Johnny flat out to pay for 1 year of college, and you do it. And then 2 years later, you go into the nursing home. That's going to get captured in the 5-year look back. You've made a $50,000 disqualifying transfer. Wonderful purpose, but it's still a disqualifying transfer. So you have to take into consideration the effects of all of this. Once a will is in effect, that means someone has died, so we don't have to worry about the nursing home anymore. But we may have a state recovery if benefits were given and somehow there are still things in that person's name. So it's all very complicated. But the trusts we talked about today are the win-win situations if they're done properly.
The other kind of question that we get sometimes is on either end, what kind of special need, other than what is obvious? A Down syndrome child, obviously we know about, and those kinds of special needs, but are there psych special needs? I mean, is there huge categories of them, and what kinds of people fall into those? You know,
it's kind of similar to who can we get a guardianship over, okay? You can have someone, for instance, the easiest way to define special needs is you're getting SSI or SSDI. Social Security has determined that you're special needs. However, you could have an estate recovery issue where I will say to the estate recovery people, well, so-and-so was on SSI or SSDI, and they will say, well, that's all well and good for Social Security, but we make our own determination as to whether that's going to qualify under our rules and regulations. So you could have a child that may be mildly retarded, borderline, they can work. Is that special needs? Who knows? You know, you go from the obvious to, you know, where there's absolutely no question but that a person is not special needs. Sometimes you have to put together a narrative. You have to say, we are proposing this person is special needs, even though they're not on a governmental benefit. Now, if they are special needs, the thought would be, well, why aren't they on a governmental benefit? Which has to do with whether they can work or not.
Right.
I had a case several years ago. It was terribly frustrating. A young, well, he wasn't young, but he was a man, an only child. He was definitely special needs eligible for a number of reasons. but he refused to go to a doctor. He refused to document it at all. That limited what his mother could do. It was a really bad case, but I couldn't force him. So.
Well, I think sometimes, you know, things like bipolar, some of the things that are in what we would call the psychological classification, they can still work, but in the eyes of our law, they're not on SSI or SSDI. But if they were an adult, somebody my age, 49, 50, and they still had parents in their 70s, 80s, 90s, and the parents wanted to make sure that they had some money when they were gone, they might look at that kind of
You can always do this type of trust. This is just a plain vanilla trust for someone. If we're not worried about public benefits, if they're not a public benefit, you can do whatever you want. You can do whatever you want. The trustee, and these are done, my neighbor was under a trust his whole life because his mother knew he couldn't handle money. And he was on that special, what we call a Spendthrift Trust until the day he died, age 83.
Wow.
So trusts themselves, when you're not worried about a governmental benefit, you can do anything with it. You can, you can lock the money up. The old common law, you'd send the ne'er-do-well son away to India, and he'd become a remittance man. He'd get his little payout from the trust each year with the admonition, just don't come back here, okay? So trusts, you can do anything with them. This is in the context of protecting a governmental benefit and making sure you're not penalized for the nursing home. Other than that, any of those situations you talked about, there's a trust that will fit the situation, fact specific.
Well, once again, thank you very much, Arthur, for coming. It's always a pleasure to have you, and it's always a learning experience, even though some of us are in this field. It's ever growing and ever, unfortunately, changing like by the minute sometimes. So I thank you for being here, and again, please remember that we do have, the show will be aired frequently, but we do have DVDs available if you need to borrow them. Not a simple matter, it's complicated, so you may need to watch it more than once, and that's why we make the DVDs, or I should say, Channel 18 makes them for us. Thank you for tuning in.
Thank you.
That's a wrap.
Oh.